So the first part of this is conflicts and ambiguities in contract documents. And obviously, we have to start with what are contract documents. Throughout here, I'll be referencing AIA and consensus docs. They're the two most popular kind of form contracts out there. Many of you are probably familiar with AIA in the Northeast, and consensus docs is, I'm seeing that more often. And frankly, a lot of the modified contracts that you get from owners are typically based upon one or both of these templates. So it's good to just kind of know the standard language before taking a look at what some owners may do to that, so you can be aware of it. So what are the contract documents? Okay, so the AIA and consensus docs have similar definitions. And typically, right, it's the contract, it's the specs, general, specific conditions, drawings, any addenda, modifications. When I say modifications, typically you're talking about a change order or a change directive. So when those are executed, they become part of the contract documents. Consensus docs also include certain owner supplied information, typically having to do with hazardous materials or asbestos abatement plans, things of that nature. So speaking to the subcontractors, again, you're going to have almost every subcontract, the prime contract will be incorporated. Either it's going to be an exhibit to your contract, or they're going to specifically reference it and say that you're bound by it. Depending upon the contract, you may be bound in the entirety or just to those portions that apply to your scope of work. That's partial or fully incorporated. And again, the law comes in here too. There's cases out there, you know, whether or not you can incorporate, for example, a waiver of a jury trial, or whether an owner, whether a general contractor can force a subcontractor to arbitrate, because there's an arbitration clause in the prime contract where the prime contractor didn't specifically put that clause in his subcontract. But generally speaking, you know, you're going to be bound to the prime contract, and that also means all of the exhibits to the prime contract and anything that the prime contract might reference. So a couple, you know, points here. Number one, your proposal. Is that a contract document? You know, a lot of times you might assume it is. It's what you negotiated. You were responding to owners' request for a proposal, and you submitted the proposal, and they say you have the job. So certainly that's going to be a contract document. No, you know, unless it's specifically set out in the contract. You know, Exhibit C, contractor's proposal dated, you know, January 1st, 2021, and the AIA contract says it's not included. And so that includes, and this is important, you know, a lot of times on public jobs, that's going to include the instructions, invitations to bid, sample forms, other information having to do with the whole bidding process. And so you'll see a lot of times in those contracts, they do make addenda, you know, addendum 1, addendum 2 will be part of the contract documents. But if throughout the process, for example, you've submitted some questions to the architect, and then the architect has submitted responses to you or to the bidding group as a whole, and those are not specifically put in the contract as contract documents, you got to insist that they are, especially if your bid and the numbers in there are based upon that clarification given by the project architect. So bottom line, don't assume that your proposal or the request for a proposal or even RFIs are contract documents. Make sure they're specifically listed or attached. And you really shouldn't get much blowback from this from either owners if you're a contractor, or GCs if you're a sub. You know, if there is some legitimate back and forth here, and your bid is based upon whatever information was supplemented. Make sure they're attached, make sure they're referenced in the contract. All right, so what about shop drawings? Are they contract documents? So AIA specifically excludes shop drawings, other submittals, as contract documents. And consensus docs doesn't specifically say they are contract documents, but they do say that just because your submittal gets approved, it doesn't alter your obligations under the contract. And as you guys know, this could be a big issue in the job where your submittals are approved by the architect or the engineer, and look at the stamp that they use, because they have about 20 of them, and I guarantee you there's going to be some qualifying or language on there that doesn't allow you to, supplement anything in the original contract documents. The approval from the architect doesn't mean that your submittal meets the contract documents, things of that nature. So be on the lookout for that.